Hello, dear students. Today our topic of deliberation is Islamic Law of Inheritance, Ilmul Faraiz, Part 1. Inheritance is one of the modes of acquiring property. The law prescribes the procedure for the devolution of property among the heirs. In pre-Islamic Arabia, the customary rules governed the practice of inheritance, which was based on the principle of comradeship in arms. This customary practice used to exclude females and minors and instead favored parental male descent, adoption, and sworn alliance or clientage. After the dawn of Islam, this discriminatory customary practice of pagan Arabs was reformed. This marked a significant departure from the previous systems. Females, for the first time in history, were recognized as competent to inherit. Besides them, widow, widower, parents, and ascendants were given the right to inherit in presence of male agnatic descendants. General principles governing inheritance. According to Islamic law of inheritance, before an estate devolves amongst the heirs, certain fundamental requirements ought to be complied with. A. Funeral expenses of the deceased ought to be taken care of. B. Debts, if any, of the deceased ought to be paid. C. Bequests, if any, made by the deceased ought to be enforced. After fulfilling all outstanding liabilities as stated above, the remaining part of the property is distributed amongst the legal heirs. In pre-Islamic Arabia, a man had an unqualified power of disposing of his property by will. Islam gradually reformed the system by laying down specific rules of distribution of property. This right of will was recognized but qualified. A Muslim was allowed to make a will subject to the following qualifications. A. A will cannot be made in favor of a would-be heir. It cannot exceed more than 1/3 of the total property. In case a will is made in favor of a would-be heir, or if it exceeds more than 1/3, the consent of future heirs becomes necessary. Amongst Shias, the rule is somewhat different, and a testator can make a will in favor of a legal heir so long it does not exceed 1/3 of his total estate. Such a legacy is valid without the consent of the other heirs, but where it exceeds 1/3, it's not valid without the consent of all the heirs. Such consent may be given either before or after the death of testator. Under Sunni law, ratification must always be after the death, and assent before death being of no effect. Competence to inherit. Every heir is entitled to inherit. This distribution is effected amongst the blood relations and marital relations. The claimants must establish the cause of inheritance, and there should be no impediment to inheritance, which is based upon near relationship, and there should be no impediment to inheritance, for example, the existence of a preferable heir or otherwise. Rule of exclusion. There are two kinds of exclusion, viz. Perfect or absolute exclusion and imperfect or partial exclusion. Perfect or absolute exclusion. There are two classes of heirs. One amongst them is not excluded at all, and the other class is such that under certain circumstances they inherit, and under certain circumstances they are excluded. The heirs which are not excluded at all are 6 in number: father, mother, widow, widower, daughter, and son. These are called primary heirs. All the other heirs, each of whom may be excluded by someone else. For example, brother is an heir. He may be excluded by the son or by the father. Brother can inherit only if the deceased has left no son or father. Illustrations. A dies, leaving behind father, daughter, widow and brother. Brother cannot inherit. Father excludes brother. Number 2. A dies, leaving behind daughter, widow and brother. Brother along with daughter and widow is entitled to inherit. Third, A dies, leaving behind widow, son and brother. Brother cannot inherit. Son excludes brother. This rule is based on the principle that nearer excludes the more remote. The perfect exclusion also applies to the cases where, although a person is related to the deceased and is otherwise entitled to inherit, there is some legal cause which excludes him from inheriting his share in the property. Examples are difference of religion, homicide, illegitimacy, slavery. Difference of religion. Under Islamic law, a non-Muslim is not entitled to inherit from a Muslim. If a Muslim by birth becomes an apostate, he cannot inherit. Homicide. A claimant who causes death intentionally or unintentionally is not entitled to inherit from the deceased under Hanafi law. Homicide bars the murderer absolutely from inheriting any property of the murdered, irrespective of the close relationship between the two. Under Shia law, only intentional killing is a bar to inheritance. Illegitimacy. An illegitimate child cannot inherit property from a father's side, but he can inherit from mother's side only. Under Shia law, an illegitimate child can neither inherit from the father nor from the mother. Slavery. Previously, slaves were not entitled to inherit. However, this rule has become almost obsolete since the practice of slavery itself by and large stands extinguished. Imperfect or partial exclusion. Imperfect or partial exclusion is an exclusion from one share and an admission to another. For example, a daughter is a Quranic heir, but by the coexistence of a son, she may be excluded as a Quranic heir and admitted as a residuary. Illustrations. A dies, leaving behind widow, father, son and daughter. Widow and father will take their respective shares as Quranic heirs. Daughter, who is a Quranic heir, will be excluded as a Quranic heir by the coexistence of son and will be admitted as an agnatic heir. Number 2. A dies, leaving behind mother, widow, brother and sister. Mother and widow will take their respective shares as Quranic heirs. Sister, who is a Quranic heir, will be excluded as a Quranic heir by the coexistence of brother and will be admitted as an agnatic heir. Females as heirs. The women in pre-Islamic Arabia were not entitled to inherit, and the reason for their exclusion was that they were treated as second-class citizens because they did not used to take part in war. Islam recognized their right of inheritance, and under Islamic law, they inherit in different capacities. She inherits as mother, widow, daughter, sister, granddaughter, grandmother, aunt, and female collaterals. Doctrine of representation. The doctrine of representation, which is not recognized in India, means that a person cannot succeed as a representative of someone who has already predeceased the deceased. For example, A dies, leaving behind son B and predeceased son C. Only the son B will inherit. C, being the son of predeceased son, cannot represent his father and therefore is excluded from inheritance. The heir is to be ascertained at the time of the death of the deceased, and a person cannot succeed as representative of someone who had already predeceased the deceased. Nature of property. Islamic law of inheritance makes no distinction between movable or immovable property, joint or separate property, reality or personality. The heirs in general. According to Hanafi law jurists, there are 3 principal classes of heirs and 4 classes of subsidiary heirs. Principal classes. A number of relations of the deceased are entitled to inherit. The principal classes include Quranic heirs, that is sharers, agnatic heirs, that is residuaries, uterine heirs, that is distant kindred. Quranic heirs or sharers. The Quranic heirs constitute class 1 heirs and are 12 in number. They are also called as sharers. The Quran has fixed their respective shares. They take their respective shares in certain order of preference. Quranic heirs include widow, widower, father, father's father, mother, grandmother, mother's mother, father's mother, daughter, son's daughter, full sister, consanguine sister, uterine brother and uterine sister. 5 Quranic heirs always inherit. They include widow, widower, father, mother and daughter. Others may or may not inherit, and their right of inheritance is determined by the presence or absence of heirs who are primary heirs, especially father and son. Agnatic heirs or residuaries. Agnatic heirs constitute class 2 heirs and by relationship are 3. Agnates in their own rights, agnates in another's rights, agnates together with another. Uterine heirs or distant kindred. The third principal class consists of uterine heirs or distant kindred. Distant kindred are of 4 kinds. Number 1, descendants of the deceased. Number 2, his ascendants. Number 3, descendants of his parents. Number 4, descendants of his paternal and maternal grandfathers and grandmothers. Subsidiary heirs. In case none of the heirs mentioned above exist, the property of the deceased will devolve to the subsidiary heirs, amongst whom each class excludes the next. Succession by contract. Succession by contract arises on the basis of relationship technically called wala. Literally, wala means friendship and assistance, but legally it signifies that assistance which entitles a person to inherit from the deceased. Basically, it is a fictitious relationship which arises in 2 situations. First, by emancipation and second, by friendship. If a master emancipates his slave, the master can inherit from the slave, but not vice versa. The second, by clientage, which implies a responsibility to pay fine to which the deceased may be liable, and in consideration thereof, the deceased has made a declaration that he shall inherit from him. This rule has little applicability in India as the consideration cannot be recognized. heir by acknowledgement. In order of preference, next comes the heir by acknowledgement. The acknowledged kinsman is a person of unknown descent who has been acknowledged by the deceased, not through himself but by another. This acknowledged kinsmanship does not extend to a son. For example, if two persons of unknown parentage call themselves brothers and one of them dies without any known legal heir, the other person would be entitled to inherit deceased's property. If a will exceeding 1/3 has been made by the acknowledger, the acknowledgee's consent is necessary to validate it. Universal legatee. In absence of everyone, as already discussed, a person is free to make a will and bequeath his entire estate to any person, known as universal legatee. In absence of legal heirs, the testator's power of bequeathing only 1/3 of the estate is not qualified. Escheat. In absence of all the heirs mentioned above, the estate devolves upon the Baitul Mal, the public treasury in an Islamic country. In India, it would escheat to the state. Under the Shia law, there is no escheat to Baitul Mal, and the property is preferred to be liquidated amongst the poor. Doctrine of aval or increase. Sometimes it is found that the sum total of fractional shares to which some shares are entitled is more than unity. In such a situation, a proportionate abatement is made in all the shares by increasing the common divisor. By aval, the fractional shares are proportionately reduced. The following illustration will explain the doctrine of aval. A dies, leaving behind widow, mother, and a sister. The heirs are entitled to following shares. Widow 1/4 equivalent to 3/12, by aval reduced to 3/13. Mother 1/3 equivalent to 4/12, by aval reduced to 4/13. Sister 1/2 equivalent to 6/12, by aval reduced to 6/13. 13/12, 13/13 equivalent to 1. Doctrine of Radd or return. When the sum total of fractions is less than unity and there are no residuaries to take the residue, the residue returns to the Quranic heirs except in case of widow or widower in proportion to their respective shares. This is called Radd or return. The sharers who are entitled to return are 7 females: mother, grandmother, daughter, son's daughter, full sister, consanguine sister, uterine sister, and only 1 male, that is uterine brother. In India, when the deceased leaves no other surviving heir except a spouse, the surviving spouse takes by return. The following illustration may elucidate the doctrine of Radd. A dies, leaving behind widow and a sister. Widow's share equivalent to 1/4, sister's share equivalent to 1/2. By return, it will be 3/4, 1/2 as sharer and 1/4 by return. Number 2. A dies, leaving behind mother, daughter, and uterine sister. Mother's share is 1/6, increased to 1/5. Daughter's is 1/2, this is equivalent to 3/6, increased to 3/5. Uterine sister's share is 1/6, this is increased to 1/5. So this comes equivalent to 5/6. By this doctrine, it comes 5/5, which is equivalent to 1. Conclusion. Islam reformed the early customary rules of inheritance. However, it did not abandon all customary practices. The Islamic law of inheritance rests basically upon the recognition of two distinct categories of legal heirs: the male agnates or asaba, the heirs of the tribal customary law, and the new Quranic heirs. This system of inheritance eliminated traditionally eligible categories and included new classes of heirs. A good number of heirs were accorded certain rights, which sometimes resulted in the division of the property into smaller shares. The Islamic law of inheritance may be summarized as: number 1, the widower and widow were made an heir. Number 2, females and cognates were recognized as competent to inherit. Number 3, parents and ascendants were given a right to inherit in presence of male agnatic descendants. Number 4, no will can be made in favor of any of heirs. Number 5, bequest to a stranger is allowed only to the extent of 1/3 of the estate. Number 6, an exception to the limit of 1/3 and in favor of would-be heir operates if the would-be heirs approve. Number 7, adoption was excluded from the ambit of inheritance. Number 8, rights of inheritance arise only on the death of a certain person. Number 9, generally the share of the female is half of the share of her male counterpart. With this, I conclude today's topic on Islamic law of inheritance, Ilm al-Faraiz Part 1. Hope you have enjoyed and understood it very well. Thanks for watching. Goodbye.